All right, I want to get to two Supreme Court cases now. Justices, they're hearing a challenge to the Affordable Care Act, also known as Obamacare. Republicans turning to the High Court here to destroy, obviously, the president's signature legislation. And the GOP allege here that part of the law that grants federal subsidies to some Obamacare recipients may be illegal. They say that people who receive federal subsidies in states that do not have state-run marketplaces is unconstitutional. Mark, is this all over language?
Well, I think we talked about this on the show before. I think that language that's in issue is a deliberate inclusion by Congress. People are saying it's an oversight. Defenders of the law, it's not an oversight at all. The language at issue was put in there to give states an incentive, albeit a coercive incentive, to sign on to the program. And therein lies the problem. And we talked about this previously. In the original Obamacare case, the specter of the 10th Amendment, which prohibits the government from coercing state policy choices, was raised. It sort of got a lot of traction in the court, but they ultimately went off on the tax ground to save the law. This is the real nub of the issue. That is it coercing state policy judgments and attaching that kind of
I don't agree. I don't think that's the issue at all, and I don't think what the Supreme Court's going to find that to be the issue. The issue is statutory.
Not in this case.
Well, that's what we're talking about. This is, and I don't think, frankly, the introduction states the issue. The issue is a different issue. The IRS has interpreted Obamacare so as to give individuals who buy into the federal exchange in the 36 states that don't have state exchanges a federal tax break or credit. The law does not explicitly give those people the credit, but only gives people the credit who are in the state exchanges. The issue that the Supreme Court took for review is whether Obamacare, as interpreted by the IRS, is being properly interpreted.
Correct.
I don't think that raises.
That's the next case.
Okay,
once
all right.
they
I'm
strike it
talking
down
about
on
this case.
No, but that's the end game here.
All right. Well, that may be, but I'm not so sure that you have 5 votes to strike this down, because the question is whether the intent of Congress when they wrote in those tax credits was to limit them to, if you will, the state exchanges as opposed to the federal.
Well,
and what would
I
be,
don't know if it's the intent of Congress. The plain language says that's what the law is.
I understand that, but the question then that's going to come up is, does the Supreme Court view it as counsel does? Is that's so clear, so unambiguous that we can't let the agency interpret it? Because the IRS
By the way, don't you like when
interpretation.
the attorneys fight, they call each other counsel? I like that
The
one.
interpretation by the interpretation by the IRS may carry the day, and if it does,
I don't think it will.
Obamacare.
And then I think you have a 10th Amendment coercion problem
be.
that's going to be very difficult to get.
I want to get to one more on the time thing here. Times, guys, I want you two guys to weigh in on this profile. Really interesting case here. Warger versus Showers. Now, the justice unanimously ruled Tuesday that jurors cannot testify about what they discussed during deliberations, and the case surrounded a crash between a motorcycle and a truck where one of the riders lost his leg here. He sued, lost the case. A jury went to the man's attorney and said, hey, there's a juror, in fact, the foreman, who based her decision on because her own daughter was involved in the fatal accident. Victim then wanted a new trial. Why not? I know it should be protected, Jimmy, what happens. It's like, what happens in Vegas stays in Vegas, the same thing with the deliberation room. But if somebody misled here in the vetting process and it perverts justice in the deliberation room, and they're bringing baggage here that obviously they never made clear when they were selected for the jury, why shouldn't that merit another trial? Why shouldn't they have testimony about that?
Well, they should have testimony about juror misconduct. There's a distinction between testimony about deliberations and juror misconduct. And we have hearings all the time when jurors come forward and give sworn affidavits as to misconduct that occurs either during deliberations or during the trial. And then there are hearings, and at least what we've done in federal court, it was sealed under some circumstances, so the juror's identity was not presented. But there should be hearings and testimony for misconduct.
You agree?
Yes, absolutely. And in fact, sometimes you'll have a juror who comes in with unique expertise, say the juror is an attorney, and that person may put himself or herself in the judge's shoes, and they're starting to give instructions to the other jurors. That's something where clearly that should be brought up. The deliberations themselves, I agree with Jim. I mean, that part should be secret. But if there's such a level of misconduct, or if someone's made misrepresentations to the parties, I think certainly it should be reviewed.
All right, I have
It's
to
how
break
you
it.
prove the misconduct, not condoning the misconduct, and you can't pierce the secrecy of jury deliberations.
We
in
got a
order to
few
prove it.
professors at the table. I really want to hear what you guys have to say about what Columbia said that students, not just law students, all students.
Just revoke its accreditation.
All right, there we go. Oh, when we come back, we're going to tell you what they're going to say given the recent news cycle and as it relates to the exam schedule. Stay with us.